Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court reserved judgment in the challenge to the demonetization policy, hearing a batch of 58 petitions that challenge the demonetization exercise announced by the Centre on November 8, 2016. A bench of 5-judge Constitution bench headed by Justice S.A. Nazir said legal compliance of the economic policy can be examined by a constitutional court. The court said that it will not go into the merits of the decision taken by the government, but can always look into the manner the decision was taken. The Supreme Court in one curious case dismissed petition wherein a man has sought compensation from YouTube for allowing distracting ads containing sexual content leading him to failing his exam. A bench of Justice Sanjay Kishan Kaul and Justice Abhay S. Oka expressed shock and disbelief and said that it is the most atrocious petition ever filed under Article 32 and imposed a cost of Rs 25,000. The Supreme Court has sided with the judicial member of the Debt Recovery Tribunal who was restrained by the Punjab and Haryana High Court from passing adverse orders in pending matters. The division bench of Justice M.R. Shah and Justice C.T. Ravi Kumar declared the impugned order as unsustainable in law. When the counsel apprised the bench that a strike was organized against the judicial member, the bench expressed astonishment as to how the bar can dominate and take over the tribunal. The Supreme Court Division bench comprising of Justice M.R. Shah and Justice C.T. Ravi Kumar observed that a candidate could not be denied appointment solely on the ground that he was tried for the offences under Section 498A IPC. The bench observed that no suppression of information and ultimate acquittal in the case earns the candidate chance to be seen in separate light from the proceedings. The Supreme Court has dismissed a petition seeking details of the Supreme Court Collegium's meeting of December 12, 2018 under the Right to Information Act, noting that the information cannot be disclosed and only finality of the Collegium decision is supposed to be known to public at large. The bench, headed by Justice M.R. Shah, observed that only the final resolution is to be considered as the final decision and whatever discussion happened to arrive at the same need not be in public eye. He added that Collegium is a multi-member body whose decision embodying the resolution that will be formally drawn and signed. He clarified that in the said meeting, consultations were not completed and concluded and therefore the agenda of the items were adjourned. Next we have Delhi High Court. The Delhi High Court, while observing that powers under Section 313 of the Criminal Procedure Code are wide enough that the courts can recall a witness if it is necessary for a just decision, dismissed one application wherein the victim was suffering 50% disability. Noting that wide powers have to be used cautiously in light of the facts and circumstances of the case, the single-judge bench opined that Prevention of Children from Sexual Offences Act is a special legislation and there are provisions in the Act itself that provide for special procedures for recording statements of a child witness. It must be ensured that the child is not called to the court repeatedly, the court ruled. The Delhi High Court has held that the writ petition filed in an attempt to renovate the contract is not permissible under law. A contract cannot be rewritten between the parties by the High Court while exercising writ jurisdiction, and the terms of the contract are to be altered mutually only as provided under Section 62 of the Indian Contract Act 1872. A division bench of Chief Justice Satish Kumar Chandra Sharma and Justice Subramaniam Prasad observed. The Delhi High Court, in a case of copyright infringement, directed Telegram to disclose the identities of creators who are involved in infringing the work of the plaintiff. The bench opined that the growth of technology cannot be a reason to diminish the significance of protection and enforcement of rights such as the right of copyright owners. It was held that the infringers cannot seek protection under the garb that the Telegram's data server is located in Singapore as Telegram runs its massive operation in India, as so it will have to work in consonance with the Indian laws. A single-judge bench of the Justice Pratibha M. Singh of the Delhi High Court, while allowing termination of 33 weeks old pregnancy, has ruled that ultimate decision involving fetal abnormalities cases lies solely in the hands of mother. The judge stressed that mother is required, among other things, to must consider also the possibility of a dignified life for the unborn child. Reflecting on Indian laws with regard to the right of women to decide on abortions while comparing it to the world scenarios, Justice Singh commented that India leans pro-choice, highlighting recent amendments. The court ruled that since judicial precedents in India have supported the rights of women to abort or medically terminate the pregnancy depending on a number of factors, including fetal conditions and health risk posed to mother, including mental health, the petition could be allowed. Another single-judge bench of Justice Sudhir Kumar Jain of the Delhi High Court has held that any infirmity in check return memo does not render entire trial under Section 138 of the Negotiable Instrument Act as nullity. The Delhi High Court has referred Parle-G and Britannia to the Delhi High Court Mediation and Conciliation Centre for resolution of dispute over disparaging of Parle's world-famous Parle-G biscuit through television advertisement, online broadcast and print media by Britannia. Now let's have an overview of other high courts. The Kerala High Court has struck down provisions of Divorce Act 1869 applicable to Christians that mandated a minimum of 1 year of separation before applying for divorce by mutual consent. The division bench of Justice A. Muhammad Mushtaq and Justice Shobha Anamma Appan noted that waiting period was legislated as one of the safeguards against impulsive decisions, but when the waiting period itself causes hardship to the parties, can the law command parties to sit at the fence and suffer the agony? The Act earlier mandated 2 years, but that was read down to 1 year in 2010 by the same court in a case, and now the court has gone further. The verdict brings the law further on par with family laws such as Hindu Marriage Act and Special Marriage Act. The Odisha High Court has opined that based on Section 125 CRPC maintenance proceedings and findings of the family court, the marital status of the parties cannot be concluded. It can only be done by civil court under Section 34 of the Specific Relief Act 1963. After the trial, the court clarified. It was further held that it would be extremely unfair if courts get into the nitty-gritty of the marital status of the parties under the proceedings of Section 498A IPC, a provision for cruelty and harassment against women with view to coerce her into accepting unlawful demands. The Madras High Court, while refusing to quash a sexual harassment case registered against a man under the Tamil Nadu Prohibition of Harassment of Women Act 2002, observed that even if harassment had not taken place at a public spot, it would still constitute an offence under the Indian Penal Code. The Kerala High Court has directed all the family courts to release arrears amount deposited towards maintenance under the order of the High Court or otherwise as early as possible, calling the reluctancy of lower court judges to be a bad practice. The single-judge bench of Justice A. Badruddin opined that withholding the amounts is detrimental to the interest of the claimants. Moving on to miscellaneous news. The Supreme Court has took exception to the comments made by Vice President Jagdeep Dhankar in his first speech as the Rajya Sabha chairman, in which he reportedly raised the issue of 2015 Supreme Court judgment declaring National Judicial Appointment Commission Act to be void. The Vice President has asked as to why in the course of 7 years the Parliament didn't take cognizance of the matter, while stressing that in a democracy, parliamentary sovereignty is inviolable. A bench comprising of Justice Sanjay Kishan Kaul and Justice Vikram Nath and Justice Abhay Oka said that the comments are not well taken and asked the Attorney General to advise government functionaries. The constitutional scheme of India empowers Parliament to enact a legislation but provides the power to courts too to scrutinize such law, the bench pointed out. A court Jamadar who shifted to online mode to collect his tips from advocates was suspended by the High Court of Allahabad. A viral image showing a QR code of payment stuck on bundle lifter went viral. Some lawyers were seen scanning the QR code and paying him the tip. Taking note of the viral image, Chief Justice Rajesh Bindal suspended the bundle lifter. The Chief Justice of India, D.Y. Chandrachud, has constituted a Supreme Court committee on accessibility with the aim of ensuring accessibility to justice system and understanding the hardships faced by specially able persons. The committee, constituted on the International Day of Persons with Disabilities, will be headed by Justice S. Ravindra Bhatt, who has been asked to conduct an accessibility audit extending to both physical as well as technology accessibility. He has also launched Android version 2.0 of the Supreme Court mobile application, which will give access to law officers and nodal officers of various union ministries to watch court proceedings in real time. The Gujarat government has urged the Supreme Court to lift the stay imposed by the High Court on certain sections of the state's amended anti-conversion law. In August last year, the Gujarat High Court had put a stay on several sections of the Gujarat Freedom of Religion Amendment Act. The law was passed with view to stop the emerging trend in which women are lured to marriage for the purpose of religious conversion. The Almora District Consumer Court has penalized public sector telecom BSNL for failing to provide uninterrupted broadband services to one of its customers, affecting the complainant's work from home schedule. An employee working with a private company had taken a broadband connection from BSNL by paying Rs 6,925. The telecom company had assured 70 Mbps speed, but the consumer told the court that he had only got 15 Mbps speed, and that too with frequent interruptions. The Delhi High Court has summoned BharatPay's former managing director and co-founder Ashneer Grover, as well as his wife Madhuri Jain, the company's former head of controls, in legal suit alleging smear campaign against the fintech firm. A Delhi court has extended by 14 days the judicial custody of Aftab Poonawalla in case of gruesome murder of his girlfriend and live-in partner Shraddha Walker. It has been alleged that he strangled her and chopped her body into pieces. In the end, we have international news. Iran has scrapped its morality police after more than 2 months of protests triggered by the death of Masha Amini following her arrest for allegedly violating the country's strict female dress code. The Tokyo District Court in Japan has ruled that the ban on same-sex marriage was constitutional, but also observed that absence of any legal system for same-sex couples to have families was infringing of their human rights. Indonesia has passed a controversial new criminal code that includes outlawing premarital sex and cohabitation. The new laws apply to both Indonesians as well as foreigners and also restore a ban on insulting the president, state institutions, or Indonesia's national ideology. The parliament has replaced the law enacted ever since the independence of the nation. In a historic move, the US House of Representatives have passed the Respect for Marriage Act, a legislation aimed to protect same-sex and interracial marriage. The bill will now go to President Joe Biden, who is reportedly looking forward to signing it into law. An Australian court has dismissed a lawsuit brought by the country's competition regulator against Alphabet Inc.'s Google that alleged consumers were misled about expanded use of personal data for targeted advertisement. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box. And for weekly updates, like and subscribe to our channel.